Hey everyone, we've got Judge Kirkham to start off
Good
with.
morning to everyone. This time and place set for the show cause hearing in this matter for contempt for failure to provide parenting time. I'll let you know we're going to take some brief, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak, so don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So on the we do have the show cause hearing. We also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So, Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to
videos the plaintiff had watched.
That gets us over the threshold of a change in circumstance or proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing. That mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's going to take these kids and run, and we're going to be in a bigger mess than we are today.
Okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's just what I had submitted to the court.
Okay, go ahead, tell me, and then
Okay, would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So we can-
Okay, I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield. I spoke to their sheriff where we looked at the videos together, and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants, and the investigation was never done. The next statement is also false. On December 27th, after the children's bath, Amelia Conley was heavily touching her private area, and when questioned who touched her potty, she said her dada. On January 1st, Evelyn Conley stated that her dad touched her on the couch. The fourth statement is false. CPS is not taking the proper steps to ensure the minor children's safety, and I did mention police involvement in the last hearing as well. The fifth statement is also false. Errors were made by the plaintiff's attorney. The sixth statement is also false. There is supposed to be a pending CPS case, and I was never told otherwise. CPS and I have spoken on numerous occasions and decided that the best course of action was therapy, which the minor children are attending at Summit Point. I do have proof of all of that as well. That's also false. I was never told that they were declining to investigate the police. Number 8. It's false. In early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. And I withheld the children again after finding videos the plaintiff had watched of children being abused, and the minor children were sexually abused during holiday parenting time with the plaintiff. The 9th statement is true. The 11th statement is false. The 12th, I'm unsure of the plaintiff's employment, but the plaintiff has stopped paying child support, and I still stay at home with my children. Number 13, I have lived at the residence that the FOC has on file since December 10th, 2024. The 14th, statement, I'm unsure of the plaintiff's relationship status. I have friends and family in Michigan, and I lived in Indiana until I was 18, and most of my family resides there. Number 15, I would like the court to consider changing the current custody orders and issue no further contact between the minor children and the plaintiff. Plaintiff should be held accountable for his actions regardless of stature or representation. That's all.
Okay, thank you. I don't need anything else, Mr. Kelly. What the court will do in this matter is the court has read the pleadings, obviously, as well aware of the file in this case. The court does believe that the plaintiff has met the Vavarka threshold of proper cause, change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter. Mr. Kelly, you can proceed with your show cause hearing. Do you wish to take testimony from your client?
Right.
Okay,
Certainly can. I have another witness that I could call as well. I just had two.
okay. Whichever you want to do first, go ahead.
I can have Mr. Connolly
Okay,
testify.
Mr. Connolly, if you step forward, we'll have you sworn in and then we'll take some testimony. And I say brief testimony, I don't need to get into.
Sure. We'll keep it straight and to the point here.
All right, raise your right hand, please. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
So
Go ahead and have a seat, sir. Go ahead, Mr. Kelly.
Mr. Connolly, could you state your name and spell your last name for the record?
Zachary Donald Conley, Conley.
Are you the father of Amelia and Evelyn Connolly in this matter?
Yes, I am.
Okay. You currently have parenting time with them.
Yes,
What is your understanding of what the parenting time is supposed to be?
every other weekend and a day during the week, in the evening. Not my weekends, it's Wednesday through Friday.
Have you been getting your parenting time?
No,
Why not?
but she is refusing to let me see them.
And when you say she, who are you referencing?
Athena Couch.
Okay. Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
You filed motions with the court to get parenting time.
Yes,
Has the court awarded you make up parenting time?
yes,
Most recently, did the court award you parenting time in January of this year?
yes,
Did you attempt to go pick the children up for that make up parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some make up parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. Couch, do you have any questions for the plaintiff? No? Okay, thank you. You may step down then, sir. Next witness, Mr. Kelly.
Your Honor, we would call Lori Connolly.
Okay, Ms. Conley, step forward, please.
Lori Putnam, Your Honor.
Okay. You're gonna make me change my.
All right. Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes,
Ma'am, could you state your last name again?
Putnam,
Spell.
Putnam.
Okay, thank you. Go ahead.
Ms. Putnam, how do you know Mr. Connolly?
He is my son.
And how do you know Ms. Couch?
She is Zach's former girlfriend and the mother of my granddaughters.
You heard him just testify that he has parenting time with your granddaughters, correct?
Correct.
Okay. Do you assist him in pickup and drop offs for
I
parenting
do.
time? Okay. What do you do in that regard?
I go with him and walk up to the door with him. to get the girls,
Okay.
to attempt to get the girls.
Has there been occasions when you have gone with him to go get the girls? And anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park. And we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach. And we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the give the girls. His first visit that he was supposed to was, I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was gonna refuse to give the girls.
And have you gone with him on subsequent occasions to attempt parenting time?
Yes.
Okay. And what has happened on those subsequent occasions?
Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted that help in terms of actually getting parenting time to occur.
No, she just did the same thing to the police.
No further questions.
Okay, hold on, ma'am. No, you're not done. Just to clarify, that he talked about prior to the December 27th date, and the court had previously entered an order which provided for makeup parenting time. And that stated that the parenting time would let's see. That the parenting time would, again, the makeup would occur on January 27, 2025. And the plaintiff's motion states that he did appear on that date. Did you go with him on the January 27th date?
Yeah.
Okay. And what happened on that date?
She just refused. I don't know, either she refused or she wasn't there.
Mhm.
Okay. Okay. And you don't remember if she was not there or if she refused?
I don't remember that specific time.
Okay,
I have it written down at home, but I don't remember.
okay. Ms. Couch, do you have any questions
I
of
do,
this witness?
yes. At what age did Zach Conley start wearing diapers?
And Judge, I'm gonna object to it.
Ma'am, that is not germane. What?
No, I am.
Ma'am, what we'll do is we're here to determine whether there was parenting time. That's the show cause, okay? So that's what the purpose of this hearing is. So you can ask questions about the parenting time, compliance with the orders, etc. Okay?
Okay,
Go ahead.
and you were at my residence on the 27th to pick up the children?
Oh, actually, on the January 27th?
Yes, or
Yes.
December 27th. Or sorry, no, January 27th. I don't have anything written down.
Yes.
Okay. Even though the order was for the 29th. Wasn't that the court
Whatever,
that the judge put
whatever
in
day,
place?
whatever judgment day.
So
I
you
don't know
just,
specific dates, whatever.
and I slammed the door in your face how many times?
Twice that I went by myself once because that was at an appointment
And
that you slammed the door in my face. I have it on video, yes.
you came alone, correct?
I did that day,
Okay.
yes.
And then, That's all. That was all I have. I'm sorry.
Okay, Mr. Kelly, any redirect?
No, Your Honor, no further questions, no further witnesses.
Okay, you may step down then. Thank you. Ms. Couch, do you wish to present any testimony or witnesses? No? Okay.
Of course, I had him muted. I wish all courtrooms
That
had
order
cameras that
because
good.
there was some. Ms. Couch, you raised some issues concerning the I think it was the order of January 27th. I want to make sure if that was the time as well for the makeup parenting time. I believe it was, but
It was January 27th through February 9th.
okay, that's what I thought. And
I could have swore the pickup date was the 29th. I apologize.
well, I want to make sure that it's correct so that there's no issue.
But I was not home at the time of pickups.
And why is that?
Because he has sexually abused our children. And I don't believe that he needs any more parenting time.
You understand that there's an order for parenting time.
If it was your children, you would be sending them with him.
I'm just asking you a question. You understand that it was parenting, that it was ordered.
Didn't you deny that? Didn't you go on base and deny it after the fact?
Not the other particular orders. I did deny an ex parte order at one point, but there were subsequent orders to that.
You guys did receive the pictures that I submitted to the court as well, correct?
Anything that was filed has been in the file.
I would love you to take that into consideration.
I would know for the court, I received no response to either of these pleadings for today's hearing.
Okay.
You got two in the mail.
Okay, the order is dated February 4, 2025. And it provided for makeup parenting time in Christmas Eve, Christmas Day, 2025. It also provided that the plaintiff would have the children with him on January 29th, 2025 at 6:00 p.m. until February 9th, 2025.
I have another question to ask you, sir.
Okay. Let me clarify that because this is the order dated February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay. And we had at the last hearing and addressed the issue of the CPS involvement. CPS, as Mr. Kelly has stated, has been involved twice before, and they've not had anything substantiated. Is that your understanding?
No, I have the CPS report right here, as well as Carla Titus's number. Now she said that her findings weren't. I need to take the kids to therapy, to get the whole picture, from the kids, them talking, them playing, them, interacting with a therapist. And so that way they can go, sorry, they can go on record. And they are in therapy at Summit Point. Now this has just started, but they've already, said some things. That was one of my questions. Do you have the report from Summit Point? They told me that I needed to sign a release so that way they could contact you.
Okay, I'm not aware of any report from Summit Point. It may be in the file, it may not. But you've not introduced that today. And you don't have anyone that could speak to that from Summit Point as a witness in this case, which is what today's date is set for in this particular matter. So that is okay. Mr. Kelly, do you have any final argument in this matter?
As the court's already touched on a little bit. This is our fourth motion to try to get him parenting time. We simply want him to have his parenting time. With the threshold being met, Your Honor, and considering the behaviors, and I think it's going to be ongoing from this couch. We request that the children be turned over to him today, that he have custody and parenting time with the children until the evidentiary hearing occurs. We'd request mom's parenting time be supervised. We'd also request the assistance of law enforcement to pick the children up. I believe they're probably with her mother, who's likely going to take the same stance as Ms. Couch and refuse to turn them over. Maybe give them the authority with a court order if she fails to do so, that she can be arrested. And in the meantime, Your Honor, we'd request a finding of contempt. Sanctions are doing nothing. You've sanctioned her $1,000, which she's a voice she's never going to pay. Doesn't have any impact on her. At this point in time, we request jail time, 30 days of jail time. Maybe that'll get her attention that she needs to follow your orders. Thank you.
Thank you. Ms. Couch, your closing argument.
I am acting I just want my kids to be safe. That's all.
Okay, thank you. Well, the court has heard again, the testimony in this case. The court will note that, again, that apparently there had been a denial of parenting time, which is not disputed by the defendant. In fact, she acknowledges that she has in fact denied parenting time. And court notes that as a result, she has withheld the children, that she's failed to comply with the order of.
But there's reason, sir.
Excuse me?
There's reason,
Okay.
valid reason.
Okay, ma'am, you're done. You don't have time to speak at this point. Okay, you've had a chance to testify, you had a chance to do a final argument, so you're done. The court, she failed to comply with the order of June 13, 2024 for parenting time. She failed to comply with the order of December 2nd, 2024 for parenting time. There was an order of November 1, 2024 for makeup parenting time and attorney fees of $500. Again, there was an order for makeup parenting time dated February 4, 2025 for makeup parenting time and attorney fees from the hearing held on January 27, 2025, that all four of those orders she's failed to comply with. The court has reviewed the file. There's been multiple show cause hearings. She has previously been held in contempt of court. She has previously been ordered to make up parenting time as well as pay attorney fees, as I stated, and she's failed to comply with any and all of these prior orders of the court. Her recourse is to file motions, have hearings in the event that there is some issue. The court will note that I am recalling from the last hearing where she had made allegations concerning the plaintiff, and in fact, she acknowledged at that time that there had been 2 CPS involvement, and the CPS had not done anything as a result. She acknowledged that she had been in contact with the police, that they had not done anything as a result either. The court will find that she is in fact in contempt of court. The court will, as the plaintiff stated, he's entitled to 20 days of makeup parenting time. And that shall occur at such time as he acquires the care of the children. The court will note that, again, the prior rulings of this court, that she had done makeup parenting time on 2 occasions, as well as paying the attorney fees, that in fact, she is ignored and refused to comply with those particular orders. So, ma'am, unfortunately, you leave me no choice, but the court will sentence you to 30 days in jail with the Calhoun County Sheriff. The court will further remand you to the care of the Calhoun County Sheriff, where you will remain until such time as the children are turned over to the plaintiff, and until such time as you have paid the previously ordered attorney fees of $1,000. So, ma'am, you can go with the sheriff, and
Are you serious?
this matter is concluded. You're free to go.
Who's
Have a good
sucking
day.
whose dick around here?
Oh,
No,
ma'am,
seriously.
Another 30 days for contempt of court. You're in jail for 60 days now.
No, what's going
If you
on?
keep going, I can go as long as you want, ma'am.
If we could have the assistance of the sheriff taking out where the girls are, we suspect they're with their with grandmother, but we're not.
Well,
100%
she
sure.
has been remanded until such time as the girls are turned over, so that she can stay there as long as she wants, I guess, until she has them turned over.
I'll draft the order in 7 days, Your Honor.
Okay, thank you.
Thank you, sir.
You're free to go. Have a good day.
All right, and there's how that one went. I truly think the mom had a good case. She just needed a good lawyer to be able to communicate it well. And, you know, I'm not saying the dad did anything. I don't know, but you know, if any of her accusations had any merit to it, they deserve to be checked out. But her mouth certainly didn't help her. She got her a good 60 days. Yep, got her a good 60 days. I'm really curious if she'd actually stay 60 days. I know sometimes we just hear, yep, Repo Dave, I see that it shows her allegations are false. It damn sure shows she can't represent herself well. She can't, you know, and imagine what them kids are hearing. Imagine the stuff they're hearing if that's how she talks in front of a judge. Just saying, imagine what she's saying about the father. So I don't know about that. Let's go to Judge Simpson. Judge Simpson had an interesting non-lawyer lady a few weeks ago, and it carried back over on Friday. I've got part 1 and part 2 of it. It's worth it. If you've seen it, here you can see it together. See it on there. It's interesting how this not lawyer lady who said she took the bar, and that's her legal qualifications, tries to run the court.
Our $J Group Holdings versus Azar Segdahi Safeld. So, what was that?
Ready, Your Honor.
Good afternoon, Your Honor.
And where are we on this?
May I pass to the bailiff to hand this to the,
What is it?
this is the petition for joinder before federal court we filed, Your Honor.
The petition for joinder?
Yes. We amended the complaint and we added R&J Holding to our federal complaint in US court.
Have you seen that?
I have not, Your Honor.
Well, you can't just give me things and expect the court to take them without showing opposing counsel.
Okay, I have a copy for him. He refused to accept.
Your Honor, she hasn't tendered it to me. Also, for what it's worth, yesterday at about 11 o'clock in the morning, the defendant served upon my office a ream of pleadings, responses, motions to stay, motions to dismiss, and so on. And I did my best.
For what case? For this
for
one?
this case. We're not a part of that federal case, and she is doing the classic attempting to turn this into a federal case, when in fact, it's just a summary proceedings action, Your Honor.
Absolutely not, sir.
And I did
No, you
also give her copies of everything I filed by overnight mail and today. I handed it to her a while ago and she gave it back to me. I'm not going to fight over it, but they served me with a series of motions. I had to
I
respond at the,
don't have any motion.
no,
Yes, Your Honor, the package in front of you has a motion to dismiss, has petition for a stay, has answer to the complaint. and
Okay,
has a
you filed these
counter-complaint.
today? Yeah.
No,
today.
we filed it yesterday, Your Honor. You only gave us a week to answer. Remember, Your Honor?
Your Honor, you gave her.
Oh, ma'am, I remember everything I do. Do not try to address me that way. I will have a memory that will throw you in circles. So don't come at me like that. Because if you come at me like that, you're going to get hurt.
I respect.
Counsel, what were you saying?
Your Honor, I was saying that as I recall, and I wouldn't challenge your memory, you may as well, when we were appeared and she asked for the opportunity to present some reference to this federal case, you
Yes.
said, we're going to adjourn this till next Friday at 3, and you can deliver to me a copy of that federal case so that I can look at it.
Right.
Not file a whole host of other pleadings and other matters at the last minute. I mean, that was tough for me to handle, but I got it out, Judge.
Well,
A copy of federal pleadings is part of that package that was hand delivered to this gentleman and to the court, Your Honor.
We have nothing to do with that federal case, Your Honor, at this point.
Now,
She
you
has a
can-
case against Wells Fargo, who was a prior mortgagee in the case. We have nothing to do with it whatsoever. We're the deed holder of the property.
there's also been a parties added.
They counterclaimed against us yesterday at 11 o'clock in the morning and filed several motions. No parties have been added to this case, but she says she wants to add us to that federal case, and I
Well,
encourage.
the caption is changed.
Correct.
Can't just change the caption.
Well, we haven't been served, and I got the document.
Counsel, I get it. I'm just saying, this caption that I have on your documents is not the caption of this case.
I'm sorry.
The caption here, who is Carl Stafford?
Carl Stafford is here. He's my.
I don't care if he's here. He wasn't a party to this case, was he?
No,
It says all residents of the house, and he's the resident of the house.
You can't just change the caption.
What do you suggest I do, Your Honor?
You don't want to hear that. I suggest maybe you get an attorney because I just don't.
she is an attorney, Your Honor.
Well, that's even more alarming. I don't even know what to do with this because the caption has changed, right?
Yes.
You served motions and apparently there's a counter complaint that the other side or whoever was supposed to add doesn't have an opportunity to answer. I don't even know if there's been a summons issued for these other parties.
Yes, there has.
Are you an attorney?
I'm not a bar license holder attorney. I went to law school.
That ranks right up there with I stayed at a Holiday Inn last night.
Counsel, you filed an amended complaint, correct?
I did, Your Honor.
All right.
We have not received that.
I gave it to her.
No, we have not received,
I
sir.
gave you the packet and you gave it back to me.
When was that,
Just
sir?
now, I gave it to
You
your
gave it
husband.
to
You
me
two want to
now.
have your own darn conversation. You can do it outside. You don't need me here.
I
I'm not going to
apologize.
be a third wheel on a date in my courtroom.
I'm sorry, Your Honor, very sorry. I did give her all of those pleadings and the amended complaint in a white envelope, which she
Did he-
handed back.
Did he give you an envelope and then you give it back?
Yes, because
Why?
because I tried to give him the joinder and he gave it back.
She never handed it
This is
anything.
like,
to me.
this is like kindergarten. I'm going to accept the first amended complaint, counsel. You can serve it on her in whatever way you wish in terms of either you can do it by email or you can serve it by first class mail. If she won't take it, she won't take it. What you filed, which starts out entitled plaintiff's defendant's answer to the counter, you're gonna have to refile this. I'm striking this pleading. You can't just change a caption. Oh, guess we're done. And so I'll give you a week to get that out. I realize it delays the proceedings, but I don't think I can do anything else. Because I don't know why these parties are running around in this case that you just added to this as the petition to stay is filed on this is crazy. You're gonna have to start over. I'm striking all of that you
Okay.
filed. And you're gonna have to just do it right. I'll take yours, you serve it, they'll have to answer, and then we'll go from there. I don't know that putting it out to next week is gonna do us any good, so I'm gonna put it out to the 14th.
Thank you, Your Honor. I would ask the court if it may. She hasn't paid rent. They haven't paid rent since November. The rent for November, December, and January is $5,000 a month. And the rent for February and March is $5,500 a month. I would ask that you ask them to escrow.
What is the current monthly amount of rent?
It's, there's a holdover provision, but we'll accept the normal rent, Your Honor.
About 5,000?
5,000 for.
I'm gonna order escrow.
Escrow, we would pay it in escrow, Your Honor, but not to them, because they have to sell the property to us.
I'm gonna order that you pay escrow to the court in the amount of $5,000. I'm not gonna do a proration back to the original. You'll start that March 1st. It needs to be paid within 7 days of the date of my order, and then needs to be paid each month while this matter is pending. Do you understand that?
Yes, Your Honor.
Please
Thank you, Your
prepare an
Honor.
order to that effect. I will
So
adjourn this.
February rent and March rent.
I can only have March rent.
March.
I could prorate a day February, but I'm
It's
not.
not necessary. We'll accept the,
March 14, 2025 at 1 p.m. I feel a cold coming. 1 p.m.
Your Honor. Have a nice weekend.
Yeah, I will now. All right, now give it. Yeah, give it, because Ann.
Can I take it?
So Fozzie, what it
Can
was
you
is
what?
she owned the house, she sold it to them.
Could we submit the joinder or no?
How she was done.
You may, if it is in proper form, submit it anything that you like, but not to me.
Okay,
You can file it with the clerk's office once the file gets up there.
by all means.
All right, Fozzie. So my
Don't.
understanding is she owned the house.
Don't.
Uh-oh.
Just
Are we dismissed, Your Honor?
bye. Yes.
Thanks, Judge.
All right, that's it. All right, so she owned the house. So she owned the house and she sold it to the company in thoughts that she's going to buy the house back, and that's where the $5,000 a month comes in. Apparently, either she's not doing the right thing, she's not paying it, or she's messing it up. But part two, they'll get into the some of the circumstances around that, and they set up pretty good for a part three. So. And part three is going to come on the 21st. So here's part two coming up here.
J Group Holdings versus Azar Stafffield. Continue to say.
Good afternoon, Your Honor. Plaintiff Anthony Momena appearing on behalf of plaintiff.
Good afternoon, Your Honor. Azar Stafford.
Your interpretation. In this case.
Your Honor, I'm not quite sure. Last time we appeared in the court had advised the parties to all reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this.
Well, the problem is, and I don't. Okay. You've not received any documents that you attempted.
Nothing
So,
since the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been filed by the defendant in this case because she had changed the caption. They were to be refiled and served.
They were not.
Was that done?
Yes,
Was that done?
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court, we did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received, he has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
We'll try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption and serve them on opposing counsel.
Yes, we
My sole question to you is,
okay.
Did you do that?
Yes, Your Honor.
Did we get a new filing? Yeah, because if she filed them and served them, they would be in my court file. And it's odd, I don't see new filings in my court file. And I don't see, and counsel's indicating he didn't get it, but she's telling me she didn't.
So according to JIS, today an answer and motion to dismiss was filed.
That was.
Not by me, Your Honor.
Yes, okay, I see that, but that was not the original.
I have not seen that.
Service on here, I don't. I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead. We did the same thing we did the last time.
And may I show this to your,
No,
this,
you did the same thing.
no, this notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case
That was
and not sign it?
I'm sorry.
You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
I am a counter plaintiff, Your Honor.
You can tell when she knows it because she gets quieter. She just talks a little soft spoken.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go on.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to.
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I am not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney
Okay.
that's licensed to practice
Okay.
to do this.
Okay. Could we have next hearing after April 1st, please?
I'm not going out that far.
Your Honor, this is the third appearance in this case.
Oh, I know.
You gave her 2 weeks after the last appearance.
To get everything right.
And you admonished her to get an attorney at that point.
I did.
Yes.
Striking those pleadings. Don't file anything else that's improper and not properly filed with this court. I'm just going to be that direct.
Okay.
Matter will adjourn to March 21st, 2020.
If I may, Your Honor, briefly, just briefly. This is not a rent case, Your Honor. This is
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak, and we need.
What way?
there's significant runoff and sediment runoff. The backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time. The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than an opportunity. She's filed this federal suit. She's doing everything possible to delay our occupancy. And I just don't think it's equitable or right. It's up, of course, your decision, Judge.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And I'm just, they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started, if at all the court would go along with us. Let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment. And then she can do what she's going to do anyway when she gets her day in court, according to her. She's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
3 different, yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I want to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. His client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was owning this place in last 9 months, the Barton Village put a lien on the property. Now we cannot get a mortgage because they have a lien on the property. And by him in this court trying to put me down because I'm representing myself is also another violation of you.
You need to talk to me.
Yes.
Go ahead.
Okay. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay. I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy, okay? This loan shark and his attorney are trying to...
Are you almost done?
Yes, to take us out of our home. And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property because it has a loan. Now he's asking us for the possession. We paid the rent, but the rental agreement is over. We want to buy the house. The lien doesn't let us buy the house, Your Honor.
I would ask for one brief moment to respond to that. If the court wishes.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond. and now you want to go back, and you want to, guys want to spend all day going back and forth. Tell you what, we can put you over there on the side. I can handle all these other people's cases, so they don't have to sit through this. I'm required to. And you guys can
Understood.
just go back and forth, and then I'm going to do what I was going to do 5 minutes ago.
Thank you, Judge.
Hearing nothing else, March 21st, 2025, 2 p.m. You get the pleadings right or get an attorney in here. Thank you.
Thank you, Judge.
Ma'am, you're not gonna yell when you're in here. You're not gonna whisper under your voice. I don't operate that way. Understood? No. Understood. I heard you all the way up here. Have a great weekend.
Thank you, Judge.
Can you, do me a favor, can you go out there and just make sure they don't
Yes.
like. I don't want to call anymore. I'm done. I'm so done. Yeah, here, you take it. All right, let's try this one.
All right, well, that was the end of that one. March 21st, they're going to do the next one, so I'm certainly going to do everything I can to be there for that one. So I'm not going to be there. I'm not that guy, but I'll do everything I can to record it and try to stream it up. So let's see. We'll go over here. Gotta go see where I'm at. We watched 2 of those. Oh, we got one more. We got another couple of good ones with Judge Simpson on the landlord docket. Let me show you a video real quick. So this is a kid. I'm not even sure where he's at. A couple of days ago, got pulled over by the police, and he just happened to have a dash camera. In the end, it's awesome to understand why you need to have a dash camera. At the beginning, I'm gonna mute it at the beginning because he's playing music, and I don't want to get in trouble with YouTube. But you'll see him get pulled over by the police, and just kind of watch it, and you'll see the value of having a dash camera. Just like every other kid, just eating while driving. I put a link to his channel in the description. It looks like more of a personal channel, but this video is getting some hits. He's got, I think, 80,000 views on this video. But his channel looks more like a personal channel. It doesn't look like he's trying to be a YouTuber. But this one's interesting here. He's just singing along to some weird song. It's just some pop song. I don't know what it is, but there you go. You can see him getting pulled over. I was muted there. I kept watching this thinking of the value of having a dang dash camera. I need to get one.
Man.
Yeah,
Officer Radford, Parkridge Police. You got your license, registration, insurance?
Yeah.
All right. Reason for the stop is I saw your cell phone in your hand when you were driving. Okay.
That was a sandwich.
It was. I saw your phone.
My phone?
Yeah.
Oh.
It wasn't. I know what a sandwich looks like. It was your phone.
Okay.
All right.
Yeah.
So it was a rectangular thing. Whether it was your wallet, your phone, it looked like your phone.
Okay.
All right. So that's why I'm pulling you over. Where are you headed to?
School.
School?
Yeah.
Hills?
Yeah.
Okay. All right, let me just run your license. If it's all clear, you'll be on your way. Okay, I'm not gonna give you a ticket. All right.
I have a previous warning.
That's fine.
Okay.
All right. I appreciate the honesty. Just give me 1 second. I'm just gonna run it. All right.
Okay. Bro. What's that? Oh my.
All right, like I said, just a warning. I'm not gonna give you a ticket.
Okay.
Like I said, if I'm gonna take your word for it, right? I trust you. If it wasn't your phone, it wasn't your phone. It looks like it was, but
Okay.
all good. All right.
Yep.
Here's your license back. All right, just drive safe, okay?
Yep. Thank you.
All right, have a good one, man.
Bro, I wasn't on my fucking phone. Oh my god, red light. Bro.
So I thought about a couple things in this video. One, that's a good kid. He had his stuff together. He wasn't disrespectful to the officer. The officer was wrong. I think the officer knew there was a chance of him being wrong. That's why he just let him off with a warning. But also the officer didn't seem to show that ego, that, that just constant push. And, okay, I'll just say there's a reason it's being shown on American courts and not Biggins. The kid didn't act up. The kid did end up not getting tased. But thank goodness that. No, people, it shows Cobra down there in the bottom corner, which is a manufacturer of dash cameras. And so, but either way, like a lot of people said, that looked like a good sandwich. Looked like it had too much vegetables on it for me, but either way, I just wanted to share that video to show, one, that a good kid, two, the benefits of having a dash camera, because he sure saved himself on it. All right, let's go to a few more Judge Simpson landlord cases. These ones are little short ones, and then we'll get out of here for the night.
All right, real good. We'll see you next week. Take care, sir. Court calls case Glencoe Hills versus Justin Jefferson.
There's another defendant as well.
Oh, there is. Yeah. Nisiki. All right, what's your name?
Justin Jefferson.
All right. How come he didn't wear all of his pants? What's up with
Oh, so I just came from training. My bad.
from training?
Yes.
For what?
NFL drafts. Yeah.
NFL draft?
Yeah, we got our pro day coming up next week, so I've been training at Eastern.
You're gonna be playing in the NFL?
Hopefully, we see. Yeah.
What position you play at Eastern?
I used to. I played last year.
Okay, what position?
Defensive end and linebacker.
Watch him, tough guy. Huh? No, I don't want to talk. He makes it. I'm gonna like show up at like training camp for his team. And I'm say, hey, you remember me? No, anyway. All right. Well, I wish you the best on all that.
Thank you, sir.
All right. How much do we have owing?
The outstanding balance is $4,651.75.
All right. Young man, how are you intending on trying to get that paid?
I just had an appointment with Hulk on Monday, and they said I just got to bring it down under 3,000. So
3,000.
I'll be able to bring that down next Friday.
You'll be able to get the 1651
Yes.
into him by that time?
Yes.
All right. So what I'll do is I'll indicate he's going to pay 1651 by I'll put the 21st. What time are they? 1? Can you get it paid before noon on
yes,
the 21st?
Yes, sir.
All right. So I'll set your court date, March 21st.
Actually, I think our pro day is that day. Can I move it?
Can you what?
Can I move it to the 28th?
What do you have?
The pro day.
Pro day?
Yes.
That's like more stuff you have to do
Yes, sir.
to get to the NFL?
Yes, sir.
So I could interfere in that, right? Should I, right? You don't want me to? Well, see, now, I'm kind of particular, so it's like, depending on what team he goes to, I may not want him to go. And he's like, I don't care what team, I just need one. All right. So the 21st, you got,
Oh, yes, sir.
what about the 28th?
Oh, I can do 28th. Yeah.
All right. I'll do this for you. I'll move it out to March 28th, 2025.
Thank you, sir.
And that's at 1 p.m.
Okay.
All right. And then get that paid by the 21st, and then you've had the hog thing. So hopefully, if you get that paid, do that, then we can get everything set.
Okay.
All right. All right. Young man, good luck to you.
Thank you, sir.
All right. Take care. Okay, so Evergreen Apartments versus Ruth Palmore.
For secretary for plaintiff. There's one other defendant.
Oh, there is.
She's not here.
Palmore and Denisha Moore.
She had to babysit.
Pardon?
She had to babysit my son.
Okay, that's fine. All right. So what do you have as the balance?
I have $2,844.54.
I paid $900 before I came to court today.
So you paid $9.
Mhm.
And so what's your plan for trying to get the balance?
I reached out to Hawk because I was supposed to have an appointment with them on yesterday, but they never called me. So my daughter reached out to him today and they rescheduled the appointment for the 19th, I think she said, at 11 o'clock.
The
Yes,
19th.
Wednesday the night, yes.
Okay.
And then I also reached out to the DHS with the SER form.
Okay.
And my son threw away the original court docket that they need. So I have to they told me when I come to court today to ask you guys for another one. And I'll submit that and then they'll go from there to see what they can do.
That was like my dog gave me homework.
No, he caught himself cleaning up and he just got rid of everything.
All right. So here's what I'll do. I'll adjourn this to the 21st since you had the appointment on Wednesday, so we can just check in and see where you're at. Okay.
Okay.
21st, 2025 at 12 p.m. And Miss Lyman so she's gonna need basically a copy of the original paperwork. So we'll give you a copy.
Okay.
Okay.
So wait back here.
Yeah, we're good.
Thank you.
Okay, thank you. Okay, come on up. Pardon? Oh. All right. Okay, how much is owing here? Oh, this is a termination. All right.
Your Honor, I believe at the last hearing, I had made a representation for the court that Ms. Palmer had not signed a new lease for the unit. And I confirmed there is no lease that has been received for the new unit.
For the new,
The unit that she is currently living in. She was in a prior unit. There was an emergency at her prior unit and she was moved to the unit that she is in now.
Black mold.
oh, just hold, ma'am.
Okay.
First of all, this is the rule we're gonna operate by. You address me.
Okay.
Understood?
Yes, sir.
I don't want you turning around. If you turn around to try to address Ms. Zeri, you're out.
Okay.
Ms. Gary, go ahead.
Your Honor, so she was moved to the new unit. We do not have a lease that's signed for the new unit. At the last hearing, she said she signed it 1 or 2 weeks after I confirmed with our client. We have not received it. They've asked
Okay.
multiple times. Happy to have it if she has a copy of it. And she also indicated that my understanding was her MISHTA caseworker was gonna attend this hearing, was not able to attend last week, and my understanding was she was going to be filing an answer to the complaint
Right.
today, which is why it was adjourned.
All right. Okay, so first thing, did you file an answer?
you got something to your email. I emailed, my information and my stuff to the thing, a number I
Okay,
got
that
on
must
there.
be,
In my,
got it. Okay, so you,
in legal aid.
she did, hold on,
Okay.
just hold on. Okay, that was done on Thursday. You did that,
Yeah.
right? Okay. So could we have a copy of this to get to this hearing? So,
Your Honor, plaintiff would like to inspect the unit.
okay,
That's,
the new, okay, all right. Okay. So they want to inspect the unit, sign lease. She did file an answer. But plaintiff doesn't have a copy, so we're getting you a copy of that. So I guess what I'm trying to clarify, if you go over and inspect the unit, unit's fine, let's say she signs the lease, do they still want her out of that unit or?
She was unauthorized dog at the unit.
Okay,
That's what this case.
okay, just listen. It's mainly about the dog.
Yes.
Okay, and you're saying there's no dog there?
no, sir,
Okay, just hold. All right,
yes, sir.
you are causing yourself more problems than you need to.
They have gave me.
Just don't want to play here. Got it?
Yeah.
Because bad things happen when you do that. What kind of dog are they claiming is there?
Did have a photo of it, but I don't.
Okay, but you don't have, okay. All right. All right, so let's do this. First thing is, are you gonna have any problem with them inspecting your unit?
No, sir.
All right, so when can we do that?
I think the window that my client is looking for is like an 8 AM to noon type of window.
All right, on any particular day or just whatever? So sometime between 8 AM to 12 noon, what day would be good for you for them to inspect?
Wednesday, because I've been taking.
Pardon?
Wednesday, because my son, I've been taking him
This
to school.
Wednesday, say the 19th?
Yes, sir.
This upcoming Wednesday? Okay, so inspection on the 19th.
We have an inspection. I think they talking about that. We have inspection coming up. They've sent papers for inspection coming up soon.
But that may have not been for the land.
Oh, okay.
It might have been for, you have a subsidy?
Yeah.
Okay, so that might be for that. All right, so we'll do inspection on the 19th. Okay. Somebody's gonna get me a picture of this dog or do whatever. So, all right. So you argue saying you signed a lease. They say they don't have a lease. Just listen. So can we get her a lease to sign? Can they do that on the 19th when they come to inspect? Because you'll be there. Right?
I'll give it to him on the 19th.
Pardon?
I'll give him the lease. I have it. It's just a reason. It's a little reason why I didn't give it to him. It's a little bigger than this. I have it and signed it already.
Okay, you signed it, but
Yes.
you haven't given it to them.
Yeah.
Okay.
Yes.
So do this for me.
Yes, sir.
When they come on the 19th, give them the lease.
Yes, sir.
Okay, that'll take care of that problem.
Yes.
And they want to inspect that. She gave an answer. And then we just have to figure out this dog thing, what it looks like. She is saying doesn't have a dog.
Because I got rid of it. I was told to get rid of it already when I moved across from there, the second apartment, and I got rid of it. So I don't know why they keep saying.
Okay,
Yeah,
so hold on a second.
So I think they think
So
it. They
hold
guess.
on, just stop.
Yes, sir.
So you had a dog.
Yeah.
They move you to this unit, tell you that you got to get rid of the dog.
Yeah.
And so you get rid of the dog.
Yes, sir.
All right, so let me ask you this.
Yes.
Did you take the dog like to Humane Society or what'd you do?
No, it grew up with my 2-year-old that just left here. So I gave it to my baby daddy, who's it belonged to. I gave it to him, back to the owner who it was. So I don't know why they keep, I was confused.
Just stop. Okay?
Yeah.
Your mouth is gonna get you in trouble.
I understand. I'm just frustrated. And I put up-
Okay. But you're making me frustrated.
I'm sorry.
So if you make me frustrated,
Well, I apologize.
bad things happen for everybody if I get frustrated, right?
I apologize.
Okay, so let's not do that.
Okay.
Okay, so. And he doesn't live anywhere in the area.
No, not, yeah.
Okay. So would he come to court if, not right now, but would
Yeah.
he come to court and say, yeah, I've got the dog?
Yes, sure.
What kind of dog is it?
It's a mixed dog, like a pit mixed with something else. A friendly, it was more like a protector dog. It had a pink thing on it I got from my daughter's ex-boyfriend.
Okay, all right. So that's what she says regarding the dog. So let's get those first things taken care of. Then we'll figure out where we're going for the dog and I can see a picture. Yes, Ms. Kazari.
Set this for a final settlement conference.
That's what I was thinking about doing. So I'm gonna set this for a final settlement conference. Next one.
Go first.
April 1st. Yes, that would be it. Okay. So I'm gonna set this for April 1st, 2025. That's at 9 a.m. Okay,
Yes, sir.
that's in person.
Yes, sir.
Okay, I won't be in this courtroom. I'll be in the first courtroom.
Okay.
Come down, okay?
Yes, sir.
All right. Now, wasn't that a lot easier when you don't start trying
Yeah.
to,
Yes,
and try to overtalk me? I don't know what.
Yes, sir.
We'll see you April 1st.
All right.
Go have a good weekend.
Yes, sir. Thank you.
Okay?
You too, sir. Thank you.
You're welcome. New Park Ridge versus Karina Jones.
I liked how the judge handled that. That could have went a lot worse for that lady, but he handled it good. All right, that's gonna be it for us. We're gonna throw in the credits and we're gonna get out of here. Thank you so much. Tomorrow morning we got Judge Fleischer, and I'm gonna try to do it live tomorrow night. I got to get back into that in the evening times. Sometimes my employer doesn't agree with me, so we have to figure that out. But we'll do all we can to do one tomorrow night, and you guys have a great night.